petitioner side, I think, you know, one of the best strategies is to really scrutinize the stipulations that petitioners are presenting. So as we've seen, these stipulations are effective. They're working, particularly the Soterra style broad stipulations. But when parties try to kind of tweak the language or make it a little different, or maybe incorporate some other idea or concern they have about something into the stipulation language, things can go awry. So here's an example of one case. This is immersion systems versus Midas Green Technologies. And the stipulation in that case from the petitioner looks very close to others we've seen, but it basically says they stipulate that if the PTAB allows them to enter the stipulation and institutes review that results in a final written decision, then they would forego certain claims. And the board here kind of picked at the specific language in the stipulation and said that this was very different from other types of stipulations the board had relied on in the past to move past Fintiv analysis. And so the board actually found in this case that the stipulation would not affect the overlap with invalidity grounds in district court because the trial was 4 months before the final written decision, as you would expect in the Fintiv analysis, because this particular stipulation was contingent on ensuring a final written decision. So this is an example of how patent owners, one strategy is to kind of look very closely at the language being used and see if it matches the types of stipulations that the board has been comfortable with, or if there's something else that the petitioner is trying to do with the stipulation.